If a grantee fraudulently obtains a deed for a grantor's property and then turns around and sells the property to someone else, can the grantor have the sale canceled? The answer to that question depends on the type of fraud involved, as the court explained in McCoy v. Love. Mary Elliott owned an interest in the minerals underneath approximately 15 acres of land in Florida. In 1972, B.G. Russell approached Elliott and offered to buy Elliott's entire mineral interest. Elliott refused, but she orally agreed to sell Russell 2 of her 15 acres. Russell fraudulently drafted a mineral deed that conveyed Elliott's full 15-acre interest and gave it to Elliott to sign. Elliott couldn't read or write, so she asked her daughter to review the deed. Elliott's daughter didn't understand the deed, but she told Elliott that it looked right. Elliott signed the deed, and it was properly delivered and recorded. Several days later, Russell called Elliott and said that he'd made a mistake in drafting the deed. He offered to pay Elliott $15,000 for the full interest. Elliott refused and demanded that Russell convey back to her the 13 acres that she hadn't agreed to sell. On February 16, 1972, Russell executed a deed that purportedly reconveyed the 13-acre mineral interest to Elliott. But unbeknownst to Elliott, 5 days earlier, Russell had already conveyed a large portion of the mineral interest to C.P. McClelland. McClelland then conveyed the interest to Clyde Love, Frank Harris, and Charles Carpenter. When Elliott tried to sell more of her mineral interest the following year, a title search revealed Russell's conveyance to McClelland and McClelland's subsequent conveyance to Love and the others. Elliott sued Love, Harris, Carpenter, and McClelland, seeking rescission of the deed. The trial court found for Elliott, concluding that the deed signed by Elliott was void because it was obtained by fraud, and therefore it couldn't pass legal title. The appellate court reversed, concluding that the deed was voidable rather than void. The court held that rescission was inappropriate because Love and the others were bona fide purchasers who didn't know about Russell's fraud. Elliott subsequently passed away, but I.C. McCoy appealed on Elliott's behalf to the Florida Supreme Court.